This is not the first time somebody's gone after Apple, and by the way, Microsoft and others for walled garden. Why is this one different?
Well, what the Department of Justice complaint says is that this ecosystem that Apple has set up and claims it's all about consumer privacy, consumer security, is in fact a mechanism to lock us into our iPhones. And I'm an iPhone user, love the product, but that they've basically manipulated that ecosystem to make it very hard for anybody to communicate off an Android system, that they're engaged in a series of actions that profit the company, but serve no useful purpose to consumers. They are trying to limit competition, the government says, in order to maintain their dominant position in the U.S. market, which is somewhere between 60 and 70%.
So, Bill, you bring up the U.S. market, but which market are we talking about here when it comes to the DOJ allegations, and how strong is their claim here?
Well, first, look, I know Apple has suggested it's a worldwide market, but that's not how antitrust analysis works. It's who are the consumers that are potentially affected, subject to price increases, to diminished innovation, diminished product quality, and that group of people are the U.S. consumers. So Apple's effort to turn this into a worldwide market, which diminishes their market share, I think ultimately is going to fail. But the government is going to have to show that these limitations that Apple puts on the use of its product are actually designed to improve product quality and not intended simply to maintain or enhance its dominant position with the iPhone. And one of the challenges that Apple is going to face is there are internal documents cited in the DOJ complaint, which suggest the motive here is to limit competition and not to protect and benefit consumers. I was in private practice many years, worked with companies who wanted to tell a public story about how everything they were doing was worthwhile and consumer-oriented. But you go through the company documents, and sometimes that's not at all what they're saying to each other inside the boardroom.
Yeah, I have to say, Bill, when I was in private practice, I never had a case there wasn't a bad document or two, and there's always somebody who's saying something foolish. But let's assume for a moment the Department of Justice actually prevails in this. They prove that there is a relevant market that they monopolize and that they've taken anti-competitive acts. What are the likely remedies? Is it really going to tear down the walled garden?
I think it's going to open up the walled garden. I don't think, the government hasn't indicated exactly what remedies they want, and that's the wise thing to do. You got to see what the court says is a problem, is an antitrust violation. But I suspect that limiting its ability to, for example, degrade the quality of messages that come in on an Android phone, preventing Apple from basically only allowing the Apple Watch to sync with your iPhone, those sorts of restrictions, which arguably are not justified, a court could say, you got to give it up. One of the interesting issues at play in this case is that over in Europe, there is a new law in effect just in the last couple of years called the Direct Markets Act. And that law is requiring Apple to do some things in Europe in terms of opening up its walled garden that it says it just can't do. And so we're going to have a track record to see whether Apple's claims that its whole ecosystem will collapse and consumers will be injured by what's going on in Europe. And, there are complaints from the European Commission about whether Apple is in good faith complying with the new terms. That'll sort itself out. And so we may have a test case that a court can look at to see whether Apple's claims that it can't do things differently, in fact, hold up scrutiny.
Well, Bill, I'm glad you brought that up because it is interesting that you have these two parallel allegations happening at the same time. And it sounds like you're saying potentially the EU case may provide some sort of blueprint, perhaps, for what's going on at home.
That's exactly how I see it. It's going to take, 2, 3, 4 years for this case to get to trial, for us to have some sense of whether DOJ's allegations hold up or not. In the meantime, Apple, which is saying we cannot do what DOJ says we need to do, is going to be having to do those very things in order to comply with the law in Brussels, the European Union law. So we'll have a sense of what works and what doesn't.
So, Bill, 3 or 4 years, that gets us into the second term of either Joe Biden or Donald Trump. Does this case survive a second term of Donald Trump?
Well, you never know, right? And given the concerns about what a second term of Donald Trump will look like, it's hard to make a prediction. One of the interesting things, though, is this investigation began in the Trump Justice Department. Indeed, 2 weeks ago, former Attorney General Bill Baer wrote an op-ed bragging about having started that investigation and kind of claiming credit for the case that was about to be brought, even though 4 years later he had no idea what was going to be in that case. But so there's some reason to believe that there is bipartisan concern with the dominance of big tech, and it's not just Apple, it's Amazon, it's Google, it's Facebook, it's others. So I'm not going to predict, but it's not 100% clear to me that this case would go away.
Bill, one last quick one, inside baseball. Why Newark? Nothing against Newark, but I wouldn't normally think that case would get filed in Newark. Are they forum shopping?
Well, the United has a really good lounge. That's one possible theory. But in the Third Circuit, which includes the district court in Newark, the government and private plaintiffs have prevailed in these cases, which are difficult to prove, that allege in unlawful efforts to maintain a monopoly. And so the case law there is more extensive and more favorable than anywhere else in the country. I don't know that's why they chose it. Someone could have a relative in Newark, but my hypothesis is that the favorable case law may have led them to initiate the lawsuit there.